Every once in a while, something really, really cool happens when you're a YouTuber, and today got to be one of those days for me. So this is kind of cool. The law firm Greenberg Glusker, which is the head litigator of which is a guy named by the name of Aaron J. Moss, who has the ability to and has been appointed to be able to litigate cases in front of the United States Supreme Court, which is not something that most attorneys are able to do, is representing Iron Mace along with another guy by the name of Josh Geller. They made the decision to send out a letter to a bunch of people and media outlets primarily, as well as Valve and me. I got to be included in this letter that they sent out. They themselves sent me a letter personally in my own email inbox and said they thought that this would be interesting for me to read since I had been reporting on the case. And that was awesome. So thanks, guys. Please keep sending me stuff. I would really like to continue working on this from the source. You know what I mean? This letter was sent to Valve. A lot of it is really convincing. And again, this is regardless of your own personal opinions about whether or not you believe Nexon to be in the right for what they are doing, or whether or not you believe Iron Mace to be in the right for what they are doing. There is going to be compelling arguments on both sides. I went through and I looked at Nexon's argument and I gave credit to where I believe Nexon's argument had merit. I also said when I didn't believe that they had merit. There's a lot of arguments that are made in this letter by an actual attorney this time, instead of just Iron Mace writing up some things, that paint an interesting picture that actually references an awful lot of case law. And I want to say, first and foremost, Aaron Moss is a damn good attorney based on the history that I've read of his. And it's good. Iron Mace needs a good attorney. So hopefully these guys see this through, because I think Iron Mace might have something here. I mean, I know I keep going back and forth, and I know Nexon has a case, but Iron Mace has a case, especially because it's being tried in the U.S. And I'll explain why as the video progresses. But we're gonna go through the letter. It's 7 pages, and it like I said, it's got a lot of detail. For those of you that want a TLDR, this letter is requesting that Valve reinstate Dark and Darker on the Steam web store and the reasons why. I don't believe that they're going to do that, mainly because Valve won't want to open itself up to potential liability if the court case ends up not going the way of Iron Mace's favor. Valve will not want to get roped into a situation where they could be held legally liable and in violation of DMCA, allowing Nexon to sue them. That being said, I think that they should relist Dark and Darker for the reasons that are outlined in this letter, because I think that there's a compelling enough case here on the case of Iron Mace to justify putting it back up. But we're going to go through it. And again, I'm trying to stay as neutral as I can. We're going to go through it, but a lot of this, I mean, some of this stuff kind of makes you chuckle. I'm not going to lie. But that's the TLDR. And for those of you that want to see the letter, we'll get into it. We'll talk about some of the legal U.S. code. And I got prior cases here on my side that I can show you some of the stuff that they're talking about. The letter goes on and starts off saying that there's material misrepresentations that Dark and Darker infringed on Nexon's copyright interests in violation of 17 U.S.C. 512F. Now, 512F talks about a person that is knowingly, materially misrepresenting that the activity is infringing and saying that they will be liable for any damages to both the copyright owner, the platform, anybody that was kind of set back monetarily as a result of it. Iron Mace submits the counter notification pursuant to 17 U.S.C. 512G3, which is basically a process that says name, address, phone number. You have to notify them in writing saying that, you know, you believe this to be false and why, and say that you also believe that the people that initiated the takedown notice knowingly did so and knew that they were being wrong about it. Saying that their claims are nothing more than anti-competitive bully tactics designed to put a small indie game studio out of business. I don't think that Nexon would ever admit to that, and they are being pushy. But they go on to substantiate the claim that they're making in the letter. Iron Mace has done nothing unlawful, and Nexon has no legal basis to prevent the gaming public from accessing Dark and Darker on Steam or anywhere else that it may be distributed. Now, we'll see. Dark and Darker is a new entry in the field of first-person extraction games. And then they say other games of this genre include Escape from Tarkov and Hunt Showdown, among others. The game has all the familiar trappings associated with the fantasy genre attributes perhaps most popularized by Dungeons & Dragons, but they're now ubiquitous to fantasy games. The gameplay is therefore somewhat similar in style to Escape from Tarkov or Battle Royales like PUBG Battlegrounds, but with characters similar to that of Elder Scrolls. Now, this is true. Obviously, if anybody's played Dark and Darker, you can see the similarities in all three of those games, Hunt Showdown 2. In the case of this actually rings even more true based on a Q&A that I did with Terry early on in September, I think, before the September playtest. We talked about the history of the game and how he got people to play it. They made a banner ad in PowerPoint and put a banner ad on 2 subreddits, PUBG and Tarkov, in order to see if they could get people to come and play it. Dark and Darker was released for a public playtest through Steam in August of 22. Nexon's crusade was against the developers of Dark and Darker, has largely kept the game out of the hands of gamers worldwide, and then it talks about how the April playtest that just happened was done so through torrent files, of which we saw between 30 and 40,000 concurrent players at any one time if the numbers in-game were to be believed, which is kind of amazing if you think about it. We now write to set the record straight, dispel any appearance of impropriety endangered by Nexon's rhetoric, and to encourage Valve to restore Dark and Darker to the Steam platform so that Iron Mace may continue to serve its fans. Now remember, neither Nexon nor Iron Mace has made a single dime off of this, and Iron Mace has converted an old BJJ dojo that was owned by Terry, where these guys started off by sitting on the floor using their home laptops and borrowing Wi-Fi from next door in order to be able to start coding their game. This is something where they have shown that they have been hungry and have been trying to get something to market for the better part of a year. That's the only way that they're going to be able to feed themselves and their families moving forward. Nexon's claims relate to a game that Nexon never made and which does not exist. That's true. There is no playable demo. We've never actually seen any actual gameplay other than a GIF, I think, of a recording and a couple of screenshots. This game was allegedly under development at Nexon before it was abandoned by the company. And they say allegedly because, again, there's never been a playable demo. Now, I don't believe that the allegedly part is really going to stick. I think Nexon has all the proof in the world to show that this was actually getting worked on and that the people that were working on it. But, of course, they're going to use the word allegedly in this letter because there hasn't been any proof yet. While under development, it had the working title P3 Project. Nexon describes the would-be game as a first-person shooter role-playing game, FPS RPG. Nexon claims to have created unique concepts, genre, plot, storyline, characters, and plans for the game. And that is true. In its original takedown letter that's here, they actually went through and said that it has just that. The level and extent of similarities between the two games' key concepts, genre, and storyline make it clear that Iron Mace must have used Nexon's trade secrets and copyrighted materials to create Dark and Darker. The letter goes on to say almost none of which is subject to copyright protection. While the expression of plot, storyline, and characters certainly may be protectable, copyright does not protect concepts, genres, or plans. And that's true. You can't copyright a concept, you can't copyright a genre, and you can't copyright a plan to make something. Nexon's loose treatment of what is and is not copyrightable is a running theme throughout its takedown notice. Nexon also claims that it created proprietary source code, art resources, and build files. Now, again, that's true because up at the top, they go through and they actually say that. Iron Mace's actions constitute, among other violations, misappropriation of Nexon's trade secrets, such as source codes, art resources, build files, and other company intellectual property under the Defend Trade Secrets Act. Now, remember, they're saying that they've copied build files, source code, and art resources. That's the claim. And of course, the burden of proof would be on Nexon to prove that they actually have. Nexon's allegations of copying are highly misleading and are almost an afterthought in Nexon's takedown notice. Instead, the vast majority of Nexon's notice is directed at a non-issue from a copyright perspective, meaning copyright claim doesn't come into the majority of the letter. Namely, Nexon's allegations that a former employee, Joo-Hoon Choi, misappropriated trade secrets from Nexon. Notably, Nexon has been pursuing claims against Mr. Choi in civil and criminal court in South Korea for almost 2 years. That's true. After years of litigation and multiple police raids to look for the supposedly misappropriated material, Nexon has found no evidence that any trade secrets were in fact misappropriated. That's because Mr. Choi didn't take any of Nexon's trade secrets. Mr. Choi has been investigated in criminal and civil court, has multiple rounds of the police coming to his house to take things, has gone to Iron Mace's labs or Iron Mace's studio, whatever, to take things and put them up and scrutinize the hell out of them. And in every single case that has been brought to court, they are typically put on a long recess or they are outright dismissed as a result of having insufficient evidence for them to actually find Mr. Choi guilty of anything. even though Nexon keeps trying to put liens on his house and his vehicle and everything else. In its takedown notice, and there's a footnote here, Nexon suggests it terminated Mr. Choi's employment as a result of discovering he'd acquired and transferred more than 11,000 key build files. They then go on to say that Mr. Choi was doing it because he was under high pressure from Nexon to perform during COVID and post-COVID pandemic scares. When Mr. Choi left Nexon's employ after being fired for pretextual reasons, Mr. Choi erased all Nexon data on his personal devices, as employees are obligated to do so upon their exit from the company. And that is true. This is the original document that was filed with the United States District Court to bring this to trial. And in here, they have a list of stuff that they are supposed to do and things that they agree to for security procedures. One of these procedures is to destroy all company IP on any personal devices that you have. In the event the employees leave Nexon, the data protection agreement expressly requires the employees to return or destroy all of the employees' trade secrets and prohibits disclosure to a third party of the company's business secrets acquired during the course of their employment in Section 21 of their own filing. So Mr. Choi, in destroying it, wasn't actually in violation of anything, if you think about it. Now, the means by which it came to that moment in time where he was under investigation from an audit team internally and then was fired, him destroying it was based on his own agreement that he made with the company when he was hired, or whenever it was that he signed it. They have a date and a time in which he signed that agreement and said that he would do that. But I digress. That sounds petty. This then goes on to say he even offered to hand over his wiped devices to Nexon, which Nexon refused to accept. Nexon instead instigated a criminal and civil suit within a month of his dismissal, forcing liens on his home, car, and bank accounts. Despite 2 years of investigation against Mr. Choi and litigation against him in Korea, there's been no evidence whatsoever that Mr. Choi ever transmitted any P3 source code, art resources, or build files to Iron Mace. He did not. And this again is true. There is no lawsuit in Korea against Iron Mace. The only lawsuit that exists against Iron Mace is this DTSA and copyright lawsuit in the United States now, which also means that they're going to be relying a lot of this on United States prior law and prior precedent. But there has been no proof of Iron Mace actually receiving any files from Mr. Choi having anything to do with Dark and Darker. None. But it is also true that they have no actual evidence. There's no actual physical proof that Iron Mace has any source codes, files, anything provided by Project P3. Mr. Choi doesn't have any paper trail. There's no electronic trail. There's no trail for them to follow. And Iron Mace has not had any files scanned, viewed, whatever, that proves that they actually took anything from Nexon. They have no proof. They have file names, but they don't have any actual source code or builds or anything. Iron Mace did not have access to, nor did it use any Nexon-owned materials to develop Dark and Darker. Nexon's assertion that it is impossible for Iron Mace to have developed Dark and Darker in such a short time frame without using Nexon's trade secrets and confidential information is similarly false. That's an allegation based on Nexon's own speed. That's not to say that the people at Dark and Darker couldn't just work faster because they don't have to deal with the bureaucracy. And I said this when their original argument got made, that seemed like a pretty weak stance to me. And I know that there are other content creators out there that think that Nexon has like this really ironclad, super strong case. I'm not seeing that. If I'm being honest, there's certain parts that look bad that they can argue, but even now, I don't see like the super strong standpoint other than having a big bucket of cash to throw at this thing. I don't see the super strong standpoint that Nexon and other people that are siding with them a bit in this case. I don't see it. I just don't. I think that they have good litigation capability, but I don't think that they have a strong case. They just have a well-rounded development team with many more programmers throughout a development period that was free of the bureaucratic, risk-adverse, and unsupportive environment that characterized Nexon, not because Iron Mace used any Nexon property. But this is a dispute between Mr. Choi and his former employer, which will be resolved in Korea. None of it impacts Iron Mace at all, as Iron Mace developed Dark and Darker entirely on its own, without using any of Nexon's proprietary source codes, art resources, or build files. And again, this is one of those situations where let's say Mr. Choi doesn't work for Iron Mace anymore. Is Iron Mace still held liable even though Nexon doesn't have any proof of Iron Mace having actually used any of their actual files? I don't know. While it is beside the point from the perspective of a copyright claim, we're also obligated to note that it is typically not unlawful for a former employee who leaves one company to later go work for a competitor. To be sure, stealing documents or assets from an employer is wrong, and that never happened here. But corporations can't legally stop employees from using their own know-how and skills to do similar work somewhere else. Contrary to Nexon's assertions That is all that happened here. What else is interesting is that because this is being tried in the state of Washington, Washington actually has an interesting law when it comes to non-compete agreements, which is something that Nexon started this with. In their court claim for their actual lawsuit, they mention the non-compete agreement right at the front. Washington State, if you're an employee for a company in Washington State, you have to make at least $116,500, I believe, in order for a company to be able to hold you to a non-compete agreement. You would have to be considered like a key employee. Therefore, you'd be paid an awful lot of money. None of these guys, based on what Nexon is saying that they were paying out and what the R&D costs were, there isn't a single person in this development team that was making that kind of money. Not one of them. It is apparent that Nexon is attempting to use its trade secret allegations to make an end run around the Copyright Act's substantial similarity requirements. But copyright law does not recognize a fruit of the poisonous tree theory, that defendants may have viewed or studied a plaintiff's program as irrelevant if the defendant's resulting work is not substantially similar to the plaintiff's. So in the case of Liu versus Price Waterhouse, which they're citing here, Price Waterhouse employed a guy named Yang that they paid to go to China to find a group of programmers that were nicknamed the Sky Programmers to improve the speed of a program, a software program that they succeeded in doing. They improved the speed of it by like 250% that Price Waterhouse was using. Price Waterhouse, assuming ownership of that, sold it to another company called Computer Language Research, CLR. And when they sold that off, the guy working for CLR made another iteration of that program and used it, whatever. The Sky programmers sold their ownership of the program that they had made, the speedier one, to Liu, who was the daughter of Yang, who was employed by Price Waterhouse to go and get this thing made. Liu sued CLR and Price Waterhouse for infringing on copyright because she owned the original work. Price Waterhouse, being an iteration of or a derivation of the original program, made it so that it wasn't substantially similar anymore. The same was true with CLR because it was a derivation of the derivation, and again was no longer substantially similar. So even though it was based on the original work, it wasn't substantially similar any longer. So Liu lost. In the case of DSC versus DGI Tech, DSC made computer processors, microprocessors. DGI went and bought some of those on the open market and then reverse engineered it. Some of their employees even went to the DSC warehouse and downloaded the operating software for the microprocessors so that they could reverse engineer that and understand and decode the firmware programming of the actual chip so they could reverse engineer it and make it work with other stuff that they had been making at the time. DSC sued DGI for copyright infringement because it broke apart, cracked their software, and then turned it into something that they could use. The government, in that case, while they said that it was really shady that DGI went in and got their software and the means by which it was acquired was really shady, because it was a derivation of the original programming and the marketed product was not substantially similar to what DSC was marketing, they had no claim over that from DGI. So it got tossed. DSC lost. They won on the software application side. They said they had to give up the software, but the stuff that they did with the software was no longer something that DSC had claim of. The test of copyright infringement has two requirements: access and substantial similarity. While DSC may succeed in proving access because DGI is not using the preferred clean room method of development, DSC must still prove substantial similarity between its firmware and the DGI firmware. Remember, substantially similar goes right down to the actual code. They had different code, so it wasn't the same, didn't count anymore. And also, in this case, they haven't even proven this part of it yet. The former employee had access to the software, but there's nothing that says that Iron Mace had access to it. There's no proof of it, much less the substantial similarity argument, but I digress. It doesn't matter if Iron Mace's developers were familiar with the P3 project by virtue of having worked at Nexon. What matters is that the creative original expression of Dark and Darker is notably and substantially different than anything Nexon authored. Once we move past Nexon's allegations of trade secret misappropriation, which again will be disproved in litigation in Korea, because again, this is the case against Mr. Choi that for the last 2 years still hasn't found him guilty of anything, it is apparent that Nexon's copyright claims have no legal merit. The only actual copyrights that Nexon points to as forming the basis of its claims are the following. Now, they have a copyright that they have filed that says unidentified source code, some unidentified source code. So the registration number that they reference, it literally just says Nexon P3 source code. There isn't any lines of actual code. There isn't any proof of the code existing. We don't have anything that we can see in the database at all. There's no proof of it. They just say that it exists. Unspecified audiovisual game material. Again, there's no specificity here. What audiovisual game material are we referencing? It doesn't have a sound file. There's nothing there. And then they say 2D character art for 6 classes of characters: Cleric, Ranger, Barbarian, Tanker, Thief, and Wizard. Nexon's takedown notice does not allege that any specific source code or other Nexon property was accessed by Iron Mace or was actually incorporated into Dark and Darker. Right? That was Mr. Choi that had access to it, but there's no evidence that Mr. Choi transferred it to Dark and Darker. Instead, Nexon claims that it conducted a comparative analysis of Dark and Darker and the P3 game, which revealed that the resource file names were identical between the two games, 2,338 of them. Nearly all of these resource files identified consist of third-party assets and plugins, which we've already covered, or they are part of the Unreal Engine build, the actual Unreal Engine. Nexon has no ownership interest in these assets. Any number of games in the marketplace purchase and use these assets with these identical file names every single day. That is true. The remaining 82 similar file names out of about 60,000 total game files consist of descriptive labels that logically describe the content of those files and are formatted in a way designed for compatibility with the Unreal Engine's assets. Simple file names like Fireball, UEXP, and Torch are not subject to copyright protection. More importantly, the fact that Nexon conducted a comparison of Dark and Darker and P3 and found similarities only in unprotectable file names, as opposed to copyrightable source code owned by Nexon, speaks volumes. Nexon isn't grasping at straws, it's grasping at the naming conventions for straws. Unfortunate and as harshly worded as that is, I do have to agree. That's true. There is no actual source code, there is no actual internals of files being alleged in the letter that was sent to Valve. From this flimsy start of its copyright comparison, Nexon then moves on to its claim that the character designs and other settings and structural designs are suspiciously similar to those of the P3 game. Nexon argues that its proto-game and Dark and Darker share character classes. Of course, these are ubiquitous fantasy character classes popularized by Dungeons & Dragons and scores of other thematically similar games. These famous and popular classes, the Fighter, Barbarian, Rogue, Ranger, and Wizard, and Cleric, are obvious scène de fer in the fantasy genre. They are characters naturally associated with the treatment of a given idea and therefore are not protected by copyright. And then they cite Gray versus Hudson, where in the write-up, in the brief, it says commonplace elements that are firmly rooted in the genre's tradition are not entitled to copyright protection. So Gray versus Hudson is a pretty well-established case between a guy named Marcus Gray and Catherine Hudson, Kate Hudson, otherwise known as Katy Perry. We all know who Katy Perry is. Now, because I can't play them for obvious copyright reasons, Gray wrote a song called Joyful Noise that has had millions of plays and is used in a lot of different backing tracks for a lot of different media. Katy Perry took a sample of that and slightly modified it into her own song, but gave no credit to, paid no royalty to Gray for the original song of his. Katy Perry's Dark Horse features that melody. So what was being argued in this case was whether or not Gray was owed some amount of money for Katy Perry using it. And in this case, what they said was the commonplace elements firmly rooted in the genre's tradition are not entitled to copyright protection, but there does need to be some form of artistic expression. In this particular case, Gray was actually found to be entitled to about 22% of the royalties that were earned as a result of this song's success from Katy Perry's side. But that's only 22% of the proceeds. The rest of the song is Katy Perry's. It wasn't really a violation of DMCA in that case. There was some revenue sharing, but they weren't guilty. See what I mean? Iron Mace has already added the Bard class in its most recent playtest and has plans to add a Warlock class, 2 more of the traditional Dungeons & Dragons classes. The same holds true for settings or locations that are commonly seen in various genres, including fantasy genres. Rosenfeld versus 20th Century Fox. Similarities are to be expected when 2 different companies make a fantasy dungeon crawler, including naturally the presence of dungeons. See the takedown notice, page 4 and 5, arguing that both games take place in a brick-walled dungeon setting. They talk about like a dimly lit dungeon setting with dark-colored bricks. That I kind of chuckled at. Such stock settings are not entitled to copyright protection and cannot give rise to claim of infringement. Now, I know at this point there's a lot of people on the Nexon side of the fence that are saying, well, the assembly of this is the thing that matters. It's not the individual pieces. But it is the individual pieces, because when it comes to defense, you're talking about each individual argument in succession. It's not just the assembly of the pieces. If the pieces themselves are tainted, it messes up the whole puzzle. But beyond just being wrong in the legal doctrine, Nexon grossly misrepresents the facts here. Similarities that it cites in Exhibit E to the takedown notice do not tell the real story. What Nexon primarily compares is the concept art for the character classes in P3 and Dark and Darker. But concept art is not what actually appears in Dark and Darker. This was essentially placeholder art present in the early access alpha playtest, which hasn't been present in the most recent iterations of the game. And that's true. Now instead, they're using 3D models. The faceplates are actually modified by the gear that are worn by each individual character as they're changed and worn. So the originating character art that was being used in the game for the placeholders for each class, that wasn't even in the April playtest. Now it's 3D models. The real characters as played look different. In any event, whatever similarities there were in the placeholder concept art were by virtue of the fact that there are certain genre conventions in how these classes are depicted. A hooded rogue or a wizard with a staff is not copyrightable. I completely agree. Like I said, the rogue looked like any typical trope rogue that had a hood and wearing a cowl. The ranger looked like a typical ranger wearing green and brown, and the wizard with a staff just reminded me of Gandalf every time I looked at him. Importantly, what happens in Dark and Darker consists primarily of third-party assets legally acquired from Unreal Engine's store. Nexon may argue that the decisions about which Unreal Engine assets to use provides the basis for some sort of selection and arrangement copyright claim, in which the way one chooses to select and arrange unprotectable source material creates a new protectable whole. True, but this claim completely falls apart for a few reasons. First, a medieval-style fantasy dungeon crawler has a limited universe of plausible assets from which one may reasonably choose. There's a reason nearly every game that has ever explored this genre features reanimated skeletons, trolls, spiders, and other usual dungeon denizens. There's nothing remarkable about a game designer choosing some of the same scene affair assets in constructing such a game. Second, a game of the magnitude of Dark and Darker uses thousands of third-party assets in the game. Even if Nexon can cherry-pick a dozen identical assets between them, that is only a drop in the bucket in terms of actual game design. Now that's true, but I will kind of give a little bit of a chalk mark to Nexon on this one. In the case of these assets, if you go to the Unreal Assets store and type in skeleton model, there's a whole lot of different options. They could have just chosen a different skeleton model or series of models to use instead of the exact same ones that were being used in P3. So to that effect, that is a little bit concerning. Also, they showed a picture in their court filing. They showed a picture of the zombie with the green cloud. That is also the same kind of zombie that spits a green cloud inside of Iron Mace's game. So to that effect, there is a little bit of a chink in the armor there. However, I will say, though, that wouldn't be the first time I've seen a poison-spitting zombie or some kind of slow shambling monster that coughs up a poison cloud. Diablo 2, Diablo 3, there are zombie-style monsters that spit poison clouds. There's mummies in Diablo 2 in the desert that spit poison clouds. Nexon does not actually have a fighter and a rogue. It has a tanker and a thief. Now remember, in Nexon's claim, tanker meant fighter and thief meant rogue. But it looked awful convenient to suddenly change the naming convention of your characters to these, if only then to try and argue that they are, again, substantially similar, which are not traditional D&D classes. They may occupy similar niches, but it's impossible to know since Nexon doesn't provide, nor does Iron Mace possess, any actual P3 gameplay to look at for comparison. It also could be a Korean to English translation thing that they decided that they were going to brush up, but Terry Park worked for them and was working on the marketing with specific instructions to try and market this to a Western audience. So if it's to be believed that he's fluent in English, and it seems like he is, it wouldn't be hard for him to make sure that the naming conventions for those character classes were right. The reality is that for every comparison Nexon can come up with, one can find half a dozen different games with the exact same feature, and in some cases the very same asset. For instance, Nexon highlights what it calls torch-related game features. Nexon does not have any proprietary copyright interest in dark, atmospheric game settings in which characters illuminate a dungeon with a torch. This sort of gameplay is popular in, for example, the Elder Scrolls or Mortal Online games. In the fact of Mortal Online 2 actually uses some of the same asset packs that this game does. Indeed, players of a certain age will have strong memories of roaming through dimly lit dungeons with torch-related gameplay as Link in The Legend of Zelda: Ocarina of Time. Simply stated, these isolated commonalities do not give rise to an infringement claim. And again, I have to agree. Just the torch is not enough. At best, Nexon has taken a handful of unprotectable elements and cobbled them together to form the illusion of a copyright infringement claim. But in reality, this case comes down to the fact that Nexon does not want any of its former employees to work at an indie studio developing a fantasy-themed extraction game. And Nexon will bend copyright law well past its breaking point in order to keep Dark and Darker out of the public's hands. To that end, Nexon makes unfounded threats against Valve, claiming that Valve may be liable not only for direct and indirect copyright infringement, but even for trade secret misappropriation if it puts Dark and Darker back up on Steam. These are nothing but baseless scare tactics. Given the absence of any colorable copyright infringement claim, Nexon's takedown notice contains knowing and material misrepresentations that Dark and Darker infringed Nexon's copyright interest in violation of 17 USC 512F. We respectfully implore Valve not to give in to Nexon's threats and to instead respect the creative ingenuity of a young gaming studio that has put out a product that is already loved by hundreds of thousands of fans eager to see the next chapter in the Dark and Darker saga. Sincerely, Aaron J. Moss, CC Josh Geller, Esquire. Now, again, I don't think that in lieu of this, Steam is likely to relist Dark and Darker just because it won't want to hang its neck out there for the potential liability involved. But again, they have a case. I think that they definitely have something to argue here. To me, this is going to be about that key phrase, substantially similar. The question will be whether or not the beginnings of Project P3, which ended up not seeing the light of day after all, whether the employees quit and P3 failed as a result of them quitting, where Nexon just decided not to hire new engineers or employees to do that, or if it was destined to fail from the beginning and the people that started Iron Mace left to start and build this game because Nexon decided they were scrapping it, has to be determined. But the end result of Project P3 and its lifespan turning into ultimately what Dark and Darker became, whether it was derivative of initial source code, which I don't believe it is because I don't think that they'd be dumb enough to hang themselves out like that. It looks like Nexon might end up having a much harder case than most people would be led to believe. Because again, they're trying this in the United States, and Nexon asked for this. And if Nexon can't prove that what Dark and Darker was actually stealing down to the source code, I think that they're going to have an issue. I'm not a litigator. I'm leaving it up to the litigators to litigate it. I'm just super interested to see how this turns out. And I would really like Nexon to shut the fuck up so that we could get Dark and Darker back on the market. I just want to play the video game, however quickly that happens. Anyway, guys, that's all I have. Thanks so much for coming and checking it out. If you would be so kind as to sub the channel here or come and check me out at twitch.tv/onepeg. I stream there every day around 6 to 7 a.m. Eastern. Although right now it's about 1:15 in the morning, and this video is probably going to get posted about 3 a.m., so I'm probably going to be late. But I'm going to try and get there. We'll see you tomorrow, okay? Well, in the next video. Either way, peace.